Hello and welcome. I am Juliet Rizzo and I will be talking with Lisa Pagano from the Office of Special Education Programs, or OSEP, about the final Part B regulations implementing the Individuals with Disabilities Education Act, or IDEA. We'll be talking about the provisions relating to procedural safeguards. Welcome, Lisa, and thanks for being with us today.
Thanks, Juliet. I'm glad to be here.
The topic of procedural safeguards is awfully broad. Can we narrow the scope of the conversation?
I think we can. We'll focus today on dispute resolution, including mediation, the resolution process, due process hearings, and the state complaint procedures, and the procedural safeguards notice itself.
That helps. Does that mean that nothing has changed in procedural safeguards except in these areas?
No, not at all. But we think it's important to focus on some of the more significant changes that will have a major impact on how public agencies and parents resolve disputes. The IDEA 2004 acknowledges there will be differences of opinion between parents and public agencies. The inclusion of the resolution process, for example, is a clear attempt to resolve these conflicts at the earliest possible stage and to avoid more adversarial and potentially costly, both in terms of dollars in the child's educational program, proceedings.
That makes sense. Let's start with the notice. What has changed about that document?
The major news with the notice document is that OSEP developed, in accordance with the IDEA 2004 requirements, a model procedural safeguards notice. It can be downloaded from our website at idea.ed.gov.
That is important news. It should really help both parents and public agencies.
We think so. Also, in response to public comments, the regulations address when the procedural safeguards notice must be provided to parents. Essentially, the notice must only be provided once a year to parents. The exceptions are that parents must be given the notice upon initial referral or a parent request for evaluation, upon receipt of the first state complaint, and upon receipt of the first due process hearing request in the school year. In accordance with the discipline procedures in Section 300.530, paragraph H, and upon request by a parent.
So, if there are no discipline issues and no dispute resolution procedures regarding due process hearings or state complaints, parents will only receive the notice once a year after the initial referral or evaluation unless they request the notice?
That's correct. We hope it reduces the paperwork burden, and the timing exceptions I indicated are in response to requests that came through the public comment process.
So, let's get to the heart of the discussion today, dispute resolution. Where should we begin?
I think the best place to begin is the due process complaint. In order to start the process, the parent or public agency must file a due process complaint that includes the name of the child, the address of the child's residence, the name of the school the child is attending, a description of the nature of the child's problem related to the proposed action or refused initiation or change, and a proposed resolution of the problem to the extent known and available to the person filing the complaint. If the child is homeless, as defined in the McKinney-Vento Homeless Assistance Act, the complaint must include contact information for the child instead of the child's residence address and the name of the school the child is attending. The resolution process comes next. It's a completely new provision and has generated a lot of discussion and questions from parents as well as from public agencies.
What exactly is a resolution meeting?
A resolution meeting is convened by the local educational agency, or LEA, with the parents and other relevant members of the Individualized Education Program, or IEP, team, who have specific knowledge of the facts in the parent's due process complaint. The purpose of the meeting is for the parent to discuss the facts that form the basis of the due process complaint so that the LEA has the opportunity to resolve the dispute.
So, the resolution meeting doesn't occur until the parent requests a due process hearing?
That's right. A parent's filing of a due process complaint is the event that triggers the resolution process. Within 15 days of receipt of the parent's due process complaint, the public agency must convene a resolution meeting. If the LEA has not resolved the dispute to the satisfaction of the parent within 30 days of the public agency's receipt of the due process complaint, the due process hearing timeline begins.
What happens if the parent doesn't want to participate in a resolution meeting?
There are two instances in which the resolution meeting does not have to occur. If the parents and the public agency agree to mediation as an alternative to the resolution process, or if the parents and the public agency agree in writing to waive the resolution process. Generally, though, the parents and agency need to go through the resolution process to get to a due process hearing.
What happens if the parent does not participate in the resolution meeting called by the public agency?
If the LEA is unable to obtain the participation of the parent in the resolution meeting after reasonable efforts have been made and documented, the LEA may, at the conclusion of the 30-day period, request that a hearing officer dismiss the parent's due process complaint.
That's a very serious consequence. What happens if the resolution meeting is not held within the required 15 days?
If the LEA fails to hold the resolution meeting within 15 days of receiving notice of the parent's due process complaint, or if the LEA fails to participate in the resolution meeting, the parent can ask the hearing officer to begin the due process hearing timeline.
I know that the due process hearing timeline of 45 days can be extended at the request of either party. Are there ways to adjust timelines around the resolution process?
Yes, generally the 45-day due process hearing timeline begins at the conclusion of the 30-day resolution period, but there is some flexibility in that 30-day resolution period. The 45-day due process hearing timeline begins the day after one of the following events. First, both parties agree in writing to waive the resolution meeting. Second, after either the mediation or resolution meeting starts, but before the end of the 30-day period, the parties agree in writing that no resolution is possible. Or third, both parties agree in writing to continue the mediation at the end of the 30-day resolution period, but then later one of the parties withdraws from the mediation process.
It sounds as if there's a real effort to encourage parents and public agencies to resolve disputes in the easiest possible way.
That's a good observation. I think that's one of the reasons why the mediation provisions also have been slightly changed. Under the prior regulations, mediation had to be made available whenever a parent requested a due process hearing. Under the new regulations, mediation must be available upon request. As you know, mediation is a process conducted by a qualified and impartial mediator to resolve a disagreement between a parent and a public agency. Making it more widely available is another attempt to encourage resolution of disputes before they require a hearing. Also, in response to public comments expressing concern about the confidentiality of discussions during mediation, the final regulations specify that mediation discussions are confidential and may not be used as evidence in any subsequent due process hearing or civil proceeding of any federal or state court in a state that receives IDEA Part B funds.
I understand that there are some rules around the agreements that result from these various processes. Can you talk a little bit about what those rules are for each of the agreements?
Certainly. Basically, a written agreement is enforceable in any state court of competent jurisdiction or in a district court of the United States. This applies to agreements reached under both mediation and resolution processes.
So, if a parent believes the provisions of an agreement are not being implemented, they have to go to court to get them enforced?
They may go to court to ensure enforcement. However, the regulations specifically state that there's nothing in the regulations that would prevent the State Educational Agency, or SEA, from providing the parties to a written agreement reached through mediation or the resolution process with other mechanisms to enforce the agreement. An example of such a mechanism might be the state complaint procedure, which we'll discuss later. The SEA cannot require such mechanisms and cannot delay or deny a party the right to seek judicial reinforcement.
Is there anything specifically new in the due process procedures?
There are several new requirements around the decisions that hearing officers make and who may be a hearing officer. For example, a person selected as a hearing officer must have the knowledge and ability to render and write decisions in accordance with appropriate standard legal practice. But the major change that will affect parents and practitioners is the time limit that was set for due process complaints. The parent or public agency must file a due process complaint within 2 years of the date the parent or public agency knew or should have known about the alleged action that is the basis of the complaint. There is one caveat, and that is the 2-year time frame does not apply if the state has its own explicit time limitation for filing a due process complaint. If the state has such a limit, the time limit allowed in that state's law applies.
And I thought there wasn't much to talk about once we narrowed the topic.
Maybe we should have narrowed it further. But I think we have one more area to discuss to be sure all of the dispute resolution mechanisms are discussed.
Let me guess, state complaint procedures?
That's right. Besides due process hearings, mediation, and resolution meetings, it's another dispute resolution mechanism in the Part B regulations.
What's the difference between a due process complaint and a state complaint?
There are a lot of differences. For instance, the due process complaint must be filed on issues relating to the identification, evaluation, or educational placement of a child with a disability, or the provision of a free appropriate public education to the child. The state complaint is a signed written document submitted to an SEA by an individual or organization that alleges that a public agency has violated any requirement of Part B of IDEA.
So, a state complaint has a broader range of issues about which an individual or organization can complain. How does the state complaint process begin?
Well, the first step is that an individual or organization would file a complaint with the SEA and forward a copy to the LEA or public agency serving the child at the same time. The complaint must be in writing and include a statement that a public agency has violated a requirement of Part B of IDEA or its implementing regulations, the facts on which the statement is based, the signature and contact information for the complainant, and if the complainant is alleging a violation with respect to a specific child, the child's name and residential address, the name of the school the child is attending, a description of the nature of the child's problem, including facts relating to the problem, and a proposed resolution of the problem to the extent known and available to the complainant at the time the complaint is filed. In the case of a homeless child, as defined in the McKinney-Vento Homeless Assistance Act, as we mentioned when we talked about filing a due process complaint, instead of the address of the child's residence, you provide the contact information for the child.
What happens then?
After a complaint is filed, the SEA must provide the public agency with the opportunity to respond to the complaint, including the option of providing a proposed resolution to the complaint. The SEA also must provide an opportunity for a parent who's filed a complaint and the public agency to voluntarily engage in mediation. There's also a time limitation for state complaints. The complaint must allege a violation of Part B that occurred not more than 1 year prior to the date that the complaint is received.
I understand that there were public comments expressing concern that the proposed regulations eliminated references to monetary reimbursement and compensatory services when an SEA finds a failure to provide appropriate services. Do the final regulations address that concern?
They do. The regulations require that in resolving a complaint where the SEA found a failure to provide appropriate services, the SEA must address the failure, including corrective action appropriate to address the needs of the child. Such actions might be providing compensatory services or monetary reimbursement.
So the final regulations address that concern directly and specifically.
Yes, and I want to emphasize that all of the dispute resolution mechanisms are drawn in such a way that the disagreements can be resolved with the least amount of adversarial action. Mediation is available upon request. State complaints offer a broad opportunity for resolving possible violations of IDEA, and the resolution meeting offers a chance to sit down and discuss the issues before proceeding to a due process hearing. We hope, and I think we mirror the intent of Congress, that these provisions encourage collaborative and cooperative approaches to solving problems and resolving disagreements.
And let's not forget the changes to the notice that reduce the paperwork burden while ensuring that parents have the information they need to participate in the special education decision-making process.
That's right. I would encourage those interested in the procedural safeguards changes to take a look at the materials available through our website at idea.ed.gov. We hope that as we implement the new regulations, we'll find other opportunities to collaborate with our partners to improve outcomes for infants, toddlers, children and youth with disabilities, and their families.
That is the common goal. Thanks, Lisa, for talking with us today about dispute resolution.
You're welcome, Juliet.
This video is one in a series prepared by the U.S. Department of Education, Office of Special Education Programs, to assist our stakeholders in better understanding some of the significant provisions of the final regulations implementing IDEA 2004. We hope you found it helpful, and we thank you for your attention.